recording when. Okay, so RT, can you make sure that you can have your slides up?
Yes, I will.
Okay.
Do I have the share screen host? I have the ability to host, right?
Yes,
You're good.
Wonderful. Okay. So hi, everyone. Again, my name is Arathi. Thank you so much, Susan, for that amazing introduction. What Susan doesn't tell you is that I have been admiring her from afar since I started in 2008 working as a domestic violence lawyer in California. I was a trial attorney basically through legal aid for about 10 years prior to coming to the Family Violence Appellate Project. And so these issues are very close to my heart. I am in Contra Costa County, and I briefly had my own practice in Contra Costa County. So I have a particular place in my heart for this county and people who are doing the work here. So I am very happy anytime I can to support the work that's being done here. Okay, so let me pull up some slides. In terms of questions, chat, things like that, I am going to be asking some questions. And so feel free to put your information in the chat, or if you want to unmute or maybe raise your hand and then we can unmute and have you talk. Feel free to put on your screen or not put on your screen if you know, whatever you're comfortable with. But yes, we're definitely open to questions. And Susan, if I could ask you to kind of keep an eye on that and just sort of, you know, because I think you'll know for sure when the questions make sense. So, okay, let's get started. And you will get a copy of this and some handouts after the training. So don't feel like you have to write everything on the slides down. All right, so let me share here. Okay, so I'm going to also, I've just figured out how to turn off this toolbar thing, so you don't have to see it every time. I realized for a long time that people were seeing a gray box on the top of my slides, and I didn't understand what that was, and it's because that toolbar was there. So, okay, so hello? Okay, so hopefully everyone can see. You're getting the slides. So this is confidentiality, privilege, and informed consent supporting survivors of domestic violence in California. Little bit about our organization. We were founded in 2012. We provide free legal representation and support to domestic violence survivors at the appellate court level. So once they go through family court and get an order, and if they, you know, if there's a problem with the order or there's an error, we help them at the higher court level to try to get that changed. And we also provide a lot of technical assistance to attorneys and advocates. We have lots of written materials and trainings and toolkits and things like that. So happy to talk to any of you about that individually or have you check out our website at another time. And sorry, I want to just stop this thing where I am seeing everybody who comes in. It may not work. All right. So just also a quick thank you to Confidentiality Institute, Alicia Aiken, who does this work nationally, National Network to End Domestic Violence, Battered Women's Justice Project are all agencies that have helped in the original development of this training. And this is just a quick disclaimer because they might make me they might make me give back my law degree if I didn't put back something in here that just says, I'm not responsible, it's not my fault, I'm not guaranteeing anything. So this is just a disclaimer that, again, you know, you really need to consult with an attorney or an expert on these issues before you actually take any action, and you shouldn't use this presentation by itself to make decisions about those things. And these are some additional resources, some other agencies that have great materials, especially National Network to End Domestic Violence. They have a whole page that's designed for service providers, as well as separate pages for clients that talk about that give samples, give you information about how to set up agency policies, et cetera, et cetera. Okay, so today my goal is really a couple of things. So normally this training or the origins of this training was specifically for domestic violence advocates, meaning people who are working in shelters, DV agencies, that type of thing, who are either already covered by having a 40-hour domestic violence training or are going to be. So given that we have a much broader audience and a slightly, different perspective, and I wanted to sort of take a step back and really talk about these general concepts, how they apply specifically in domestic violence, but also then, why we should care, aside from the fact that there's laws about it. So I want to start with some of my first questions. So, and honestly, I know that these are broad questions that could take their own day or their own presentation. But if you're like me and you've just felt like the last couple of weeks you've been through the ringer with all the news, one of the things that has been out there has been a discussion about the right to privacy. So just some thoughts. When you hear the word privacy, what do you think of? What does it mean to you as a person? And who do you think makes the decisions and what kind of information? Just what are your thoughts on any of these issues? I'd love to hear what you think. It's a tricky thing because we have privacy as a generic term in society, and then we have privacy which has very particular meanings in certain contexts. Any thoughts or?
So I think people are being a little shy since this is the first,
Yeah, I know,
set of
sorry.
questions. But I think
there's no wrong answer, please.
Are we
just
supposed
an
to
event.
speak up, or are we supposed to put it in the chat?
You could speak up, Tanya. Go ahead.
Okay, I mean, I would say it's control over information that we want shared about ourselves. So
okay,
ideally, we would have the right to allow somebody to share information that we shared with them.
great. Okay. Anybody else?
Swastika shared in the chat that it's subjective to the individual depending on the situation.
Okay.
Safety. Leslie, thank you.
That's a great point, and hopefully we'll keep talking about that. Other thoughts?
Something about that people should not know my own private business.
Mm-hmm.
And it should be up to me what people know about me. In the chat box, thank you.
Great, thank you. So just something, I mean, feel free to keep putting them in, even though I'm talking. So just some things to notice about some of the responses you've already heard, right? The word right has been used. So there is this concept maybe that you just have it, right? It's not always clear where that right comes from. Is it something written somewhere, or is it something that we just have inherently? But it's seen as a right. There were words about choice and who makes those choices, right? And definitely the focus or the responses seem to reflect the fact that there's an individual choice, right? And it's an individual choice about your own information. So yeah, I think that those are all things that we definitely think of when we think of privacy in a general context. Now, in the context of domestic violence, this is not necessarily different, but I think it's important to be even more specific than we may be otherwise, right? So similar to what people said, it's the individual right to choose whether or not to disclose information, right? But when we talk about the right to choose, we want to be really clear about what that means. So that right to choose means it has to be an informed choice. And we're going to talk about informed consent and what that looks like. And that includes what information to disclose, when to disclose it, how much, for how long, for what's the purpose, for what's the context. There's so much more to disclosure and choice about disclosure, particularly in the context of domestic violence, that if particularly if you are supporting survivors and they are your clients, you want to make sure that that broader view is there, and it's there for you as well as the person that you're working with, right? Any questions about that? All right. So how can privacy be affected by domestic violence? So hopefully some of us are aware of already the fact that privacy is often used as a tool of abuse, right? So information can be withheld. You can withhold information about immigration benefits, about health benefits, about contact from other family members. Access can be controlled, right? So you can't look at that information. You're not allowed to talk to your child's doctor. You're not allowed to go to these appointments. It could be monitored, right? I have to always be there when you see the doctor. I have to always go with you when you do these things. Or, as we know, I have a keyboard tracker on your computer. Or I put something on your car, or I have something in your phone. I have find your iPhone or family share on the phone, so I have to know where you are all the time. And then also information disclosed without permission, right? So it could be something like, I'm going to tell your parents, I told your parents, or everybody knows this about you, or purposely revealing information in a public setting that you would not want to be, disclosed. Sometimes we see that in situations where, an abusive party might talk about their partner's mental health in front of other people as a way to discredit them publicly prior to any effort they might make to try to get safety. And specifically can be used to coerce and control specific behavior, right? This is not an exhaustive list, but this is just an understanding of how it can be used. So when you think of this in this context, right, privacy comes to mean safety in a different way. So the person who said privacy is safety, I think, that's a very important concept to think about, right? Because most survivors of domestic violence have already experienced their privacy being abused in some way. Maybe not maybe not GPS on the car, but in some ways their privacy has been abused already. So you have to start from that understanding that you might be working with a person who has either never been allowed to make that right real for them, or has somehow had that right taken away from them. Okay. Privacy can also be an implicit or explicit requirement for services or safety, right? I'm always mindful of how, when you give referrals to someone who is seeking services, right? They'll tell you, I called all of those people and I had to do an intake with all of them and I had to tell them all my whole story and then they still didn't help me, right? I mean, it's heartbreaking when you hear that. And that the individual agencies, maybe they couldn't help because someone was in the wrong geographic location, or maybe it's not an area that they provide. It's not an intentional act to, not serve someone, but the privacy that the person has lost as a result of having to try to get these services is profound. And it's not something that necessarily everyone thinks about, right? You're leaving a situation where your privacy has been abused. Part of what you're leaving for is hopefully to take back your privacy. But in order to take back your privacy, you have to give all your information to all these services. So it's a real conundrum, I think. And it's important to recognize that kind of push-pull and those contradictions that a survivor has to go through in order to achieve their own sense of safety, right? And even something, I put this at the end here because it's something that in the legal profession that I think that we don't think enough about is, we talk a lot about protective orders, restraining orders, calling the police, doing those kinds of things. And then the expectation is you tell everybody around you that you've done those things so that they also know what's going on, so that if something happens, right? If you, if you get a restraining order and the abusive party is supposed to be prevented from going to the children's school or your work or your house of worship or something like that, the expectation on the survivor is for them to go and give a copy of this restraining order to all these different places, right? That is a privacy requirement in a way, a breaking of privacy requirement in a way that you have to do as a condition of safety. And it's expected, or it's sort of just assumed, that people will be okay with that, right? Even though it feels embarrassing and maybe it feels, like too much, or maybe you don't want everybody to know, or to think of you in that way. We also, more recently, as you may know, we have laws that now are in place that make it that certain agencies are going to have policies in place so that if they know that there's a restraining order, they know that they're not allowed to give out certain pieces of information. You may have heard of this already, but it was unfortunately, like a lot of laws in our state, it's something tragic happens and then we decide, oh, maybe we need a law to do this. But it was a situation where someone had a restraining order and information about their location was given to the abusive party, and the abusive party was able to use that information to commit homicide. And this was a medical place. So that kind of understanding of, like, to get services or to get safety, I have to put myself out there, and even that may make me less safe, is something that survivors know. We're not protecting them from that. So it's really important to understand not only the context from which a survivor might be coming, but the context in which they might be operating to get services and seek safety, which is an ongoing privacy issue, right? Any questions about that? Any comments?
Arati, this is Susan. I think these are really important considerations I really hadn't thought of. And we have, case managers and social workers in our meeting right now. And, probably a lot of us haven't really thought about how much information our clients are sharing and what privacy really means. So I really appreciate, framing this conversation this way. And I think someone mentioned in the chat that this is really about self-determination as well as safety. And I think you're going to probably talk a little bit more about informed consent. But
Yes.
I think it's really important for us to remember that all of the information that our clients are sharing really is theirs, and we need to think about their privacy. So I appreciate this.
Oh, thank you. Yeah, no problem. And we will be getting to that actually even earlier. So we're going to now talk about confidentiality, right? So what is confidentiality? Confidentiality is our responsibility, and I use that word very purposefully. It's our responsibility to protect someone else's choices about the disclosure of their information. So in a nutshell, it's our responsibility to protect our client's privacy or someone else's privacy, right? So if you think about what we just talked about, there's this realm of private information, right? Information that a survivor wants to keep private. And within that, there's information that they may have shared with you, and you have a responsibility to keep that information confidential, right? So this can sometimes visually, this is a bit helpful, right? The realm of private information that a person has is much bigger than the information that will be shared with you. But once it's shared with you, you have a responsibility to keep it confidential if you are particularly working in service provisions for domestic violence, as well as in, depending on your profession, in certain other ways as well. Okay, so why does it matter? What's the ultimate purpose, you think, of confidentiality protections, and who are the protections intended to serve and help? We throw confidentiality around a lot, I think, just like privacy. But what's the point? Why isn't it enough to just know that a person's information is private? Why do we need confidentiality policies? Why do people need to know about confidentiality?
establish trust is in the chat box. Thank you, Adeline.
Thank you. Others?
Swastika shared information is power and may be used against the client.
Mm-hmm. Mm-hmm. Anything else? So yeah, as people said, you know, the ultimate purpose of confidentiality protections is to create a safe environment for people to disclose to the extent they need to help them, right? That's really what it's for. It's not about, you know, do I go to court with this or do I go to court with that? Did someone tell me this is not something to be told? All of those kinds of things. The ultimate purpose is to create an atmosphere of safety and trust that will encourage people who need services to access those services to the extent that they want to, right? And that's who the protections are intended to serve and help. And I think that's another thing to keep in mind all the time. Confidentiality protections are not a burden. They're not meant to be, you know, a restriction to feel like you can't do things. They're not meant to be something that, you know, you're always having to kind of feel like you're walking on eggshells about, right? Confidentiality protections are there to serve the purpose of supporting survivors of domestic violence in the context of what we're talking about. But generally, right? Confidentiality protections are in place to serve the person who is receiving services, whatever, in most situations. It puts a responsibility on us, but the responsibility is there because of that need to support, right? So where are confidentiality protections, right? We talked about sort of the right to privacy and, you know, is it inherent in your, you know, self as a human being? Is it in law? Well, confidentiality protections, believe it or not, are actually written into laws. So these are some of the places where you might find confidentiality protections: federal law, state general law, business and professions codes, which are codes, say, for example, attorneys, people who work in the hair industry, people who work in all kinds of different industries have codes under the business and profession codes for how they're supposed to operate, how they're supposed to run their business, how they're supposed to behave towards their customers. And then, of course, ethical standards for licensing and professional bodies. Right. I know some of you on here have identified yourself as MSWs and LCSWs, and so you know you're aware as well that separate from whatever there might be in the code as a condition of your license or a condition of your being part of a professional body, you have certain standards, right? So they don't come from nowhere, right? They definitely exist and they're there, and there's something that we can draw upon, right? So federal confidentiality laws. In the context of domestic violence, definitely, hopefully a lot of you know about the Violence Against Women Act, Victims of Crime Act, and the Family Violence Prevention Services Act. The Family Violence Prevention Services Act is generally the federal bill that covers funding for shelters. So not everybody gets that money, but a lot of places do. A lot of places get Violence Against Women Act funding or Victims of Crime Act funding, right? And confidentiality is baked into these laws and baked into the requirements for receiving funding under these laws. Hipaa, something probably all of you are familiar with, right? That's just another example of, and when you think about it, right, Hipaa didn't always exist. Right? Hipaa came into being because what was happening was not adequate to protect the privacy of folks, right? So they created this in order to enshrine concepts of our responsibility to keep information confidential. And Family Education Rights and Privacy Acts, FERPA. So, you know, that's about student educational records, right? So these are just some of the places where you'll find provisions about confidentiality in federal law. The Violence Against Women Act specifically prohibits agencies from disclosing personally identifying information about clients who are victims of domestic violence, dating violence, sexual assault, or stalking, right? And you'll see in the Victims of Crime Act, there's similar language talking about trafficking and crime victims that's other crimes that may also involve gender-based violence. And it includes information about people who merely request or denied services by an agency. Why do you think that is? Why did they need to include that? Maybe that's too obvious a question. I don't know, but what do you think?
Is it because, oh, someone says ensure safety. Swastika said safety.
Mm-hmm. I mean, think back to that person I was telling you about who had to call 5 different agencies to get help and wasn't able to get help from, 4 of them, right? If only the agency she got help from had to keep the information confidential, then how does that protect her privacy really, right? So you have to be able to include people who are not participating in services, who are not able to get services, or who are just inquiring about services, right? Again, disclosure, you want people to ask, you want people to call and find out, can you help me, right? And be able to feel like they can do that and then make a decision about whether they want to get help, rather than be, locked in or tied in or having given up information that they can't control anymore in order to do that. Victim service providers are generally nonprofits. Oh, go ahead.
Alrighty, just one more thing. Can you briefly talk about what you mean by personally identifying information?
We are getting to that.
Oh,
I have
okay.
a whole slide on it. So,
Right, so
yes, absolutely. Great question. So victim service providers are nonprofits, right? That's a big important thing, nonprofits, all right? And it includes places that are not just shelters, but transitional housing, rape crisis centers. The exception is for court order or mandated by statute, right? So prohibits agencies from disclosing personal information, identifying information, except for by court order or mandated by statute, right? So that's your responsibility right there, right? No court order, no mandate by statute, don't disclose, period, right? What is personally identifying information? Okay, here we go. So basically, personally identifying information includes the name of the client. It can include the name of the children, home address, email address, phone number, social security number. Apparently the year is okay for date of birth, but that's sort of the general focus of personally identifying information. But really in the context of our work and in the context of the purpose of the law, it's really any information that would enable a person to identify who that client is, right? If I have a client with 7 children and
yeah, that's what I want to say.
Hello?
no, we got it. We
Okay.
muted.
If I have a client who has 7 children and I happen to work in Alameda County, right? Maybe there's a way that someone would figure out who that is. Or, I happen to have a client that uses a Burmese interpreter, right? How big is that community? Where is that community, right? Where are interpreters in that thing? What are the chances that that person could know through a friend of a friend of a friend, who that might be or could figure it out? If you've ever done work with survivors already, or if you've done work in situations where you do have a responsibility to keep information confidential, what's happened when you've run into somebody? Have you ever run into somebody that you've worked with in a public place or somewhere outside the context of work? Maybe it's someone you're treating, maybe it's someone you've treated, maybe it's someone you're working with. Has anybody had that experience, and what have you done? Well, that's great. Apparently, I take BART and my clients take BART a lot. So I have these situations quite often, or at
So
least I used to. Okay, someone answered.
yeah, someone answered, pretended I don't know them until they acknowledge me for their safety.
Yeah.
I did too. I've run into clients in a grocery store, and I just kind of redirected to, I'll contact you on Monday, or but not have, I didn't have that conversation there because it was in the grocery store line. So just redirecting.
Well, I mean, even further than that, I used to tell my clients up front, if I see you in public, I'm not going to acknowledge you. Because if someone sees me with you, they could infer that you are a victim of domestic violence or that I'm providing you services. If you Google my name, you'll see all kinds of stuff that relates to domestic violence, right? So just by talking to me in public, someone could inadvertently or somehow, somehow there could be a way that they could, draw from that information that I'm providing them services as a survivor of domestic violence. So I don't leave it to chance, right? We talk about it up front. And that's part of information that may not seem personally identifying, but could enable a person to identify a client, right? California laws. So California, we have the Domestic Violence Shelter-Based Program Act. That's the law where most shelters get their funding from. We have a civil code section, business and profession code, which I mentioned, and confidentiality of medical information. So we have these federal laws that have these rules, and in California, we've made the decision to have some more specific laws that either strengthen or repeat what's in the federal law, or in fact go further than the federal law. So for domestic violence shelter-based programs, those are programs that get marriage license fees, right? And because they're getting money from the county, in some cases, you might think that because they're getting money from the county, they are required to have to give some information, right? But it specifically prohibits the county from asking agencies to give personally identifying information, right? Just because they give you money doesn't mean they buy access to confidential and to information you have a responsibility to keep confidential, okay? They can request some general aggregate stuff, but they cannot require any of this. Now it says exception, reporting child abuse if mandated. That's a slightly different thing. That's not really the same as the county asking. But it's technically that because it's a county department. But really what this means is the county agencies that are giving out funding are not supposed to act that. Okay, California funders. So this is a general rule too. It's not even just specific to marriage license fees. But in awarding grants or providing financial support, it's unlawful for a person or entity to require that a victim service provider provide personally identifying information because it's basically, as part of the grant application, right? So basically the counties, the state, public agencies are not supposed to use the fact that they either want to give you money or are considering giving you money as an opportunity to have you disclose information that you have a responsibility to keep confidential, right? Business of profession codes, attorneys, we talk about sort of attorney-client confidentiality, privilege. In California, it's very strong. It's even stronger than a lot of other states, right? So for example, an attorney may, but is not required to reveal information necessary to prevent a criminal act, right? Codes of ethics for social workers. For those of you who are already social workers, you probably all know this, but just if you're not, especially, social workers have confidentiality rules as social workers, independent of whatever their organization is doing, right? And it's not even just, it's not even just a matter of don't disclose, but even in the disclosure, and you see this with the other laws too, it's least amount of confidential information necessary to achieve the desired purpose, right? And that's a theme that's going to come up in our discussion today, right? Is what's the purpose, who is it for, and what do you actually need to disclose for that purpose, okay? And all of these things as well, you'll see both in marriage and family therapists and in social workers, and you'll see this with domestic violence as well. Review with clients the circumstances where confidential information may be legally required, right? So what are some of the obstacles to confidentiality? One is we're going to go through these. So these are what I consider some obstacles, and I'd be curious to see if you think there are others. So one is that the victim survivor, and I use that term just generically. I know that different people who experience domestic violence consider their situation differently and may label themselves as something different. The myth of the perfect victim survivor, a failure to build a relationship of trust, and assuming we know better, right? So what is your relationship to the victim survivor, right? What is the supposed purpose and goal of any interaction with the victim survivor? And again, what is the purpose and intent for the information sought, right? There are lots of services for domestic violence survivors that are not provided by domestic violence shelter agencies or by domestic violence counselors. There are lots of services through particularly public agencies, for example, and other places where there may be private information of a survivor that needs to be disclosed, that you are supposed to be keeping confidential, or you should be keeping confidential, but you're not a domestic violence counselor, or it's not a domestic violence service agency, right? So as part of what I consider to be a broader universe of understanding these concepts and working collectively to protect them as being good for all of us, it is important, what's your relationship, right? If you are someone who is directly providing services and that's the goal of your agency, that's your, this person is your client, that's a pretty straightforward way to be able to think about it, right? If you work for a larger entity, if you work for the government, if you work for, a broader array of interests, sometimes that can get a little fuzzy, right? And you really need to be clear. And if you are clear, you need to be clear with the person you're working with, right? Hey, my ultimate goal is going to be the children, and I'm allowed to prioritize their needs above yours. If in my judgment, that's the way it's going to go, right? And what is the purpose and intent for the information sought, right? Information, and I don't mean any disrespect to any profession here, but information that is sought in the context of a criminal investigation is generally for the purpose of determining whether there's enough evidence to bring charges and there's enough evidence to prosecute, right? That's independent of whether the victim survivor may or may not want to prosecute. This is not to say that district attorneys' offices or those offices don't take that into account or anything like that, but there's an independent purpose and goal and responsibility that those offices have, right? That's different from the purposes, responsibilities that a domestic violence counselor might have, or somebody who's working for the Department of Social Services might have, for example. Okay. So enduring myth of the perfect victim. So I wanted to bring this up because this is actually a case that came out last year. And I just wish I could, I wish I could find a way for every single judge and juror and legal person to sort of absorb this by osmosis. Because this is a case, it's a dependency case, which means it's a case where Child Protective Services took away this woman's child, right? And in the appeal, they basically said the child shouldn't have been taken away, right? And in saying that, what they talked about is that there's a trend of what looks like mothers in particular in this particular case, but parents being punished as victims of domestic violence. Indeed, it seems as if once a woman is battered, she will be forever faced with losing her children, and that is not the legal test, right? So when you talk about privacy, disclosure, and those kinds of things, survivors understand that it's not static. It's not like, oh, I tell you this one time and it may never come back to bite me later, right? Because depending on the context, it has been used against them later, right? There are Child Protective Services cases where, if a survivor has not obtained a restraining order from family court, even though they have no control over whether the court actually issues one, that's held against them, right? So it's not always a simple matter of, I give this information, I'm going to get help, and everything's going to be great, right? There are consequences to seeking help, and there's consequences to taking services that survivors understand. People talk, people know in the community, people hear rumors, they get, there are people who scare each other. People get scared by other people in shelter, right? You get told, oh my God, I would never do that because, blah, 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 right? So your clients or people you're working with are getting lots of information from other places. And some of that information includes information that may be very similar to what they're being told by the abusive party, which is that you are going to get in more trouble if you say something than if you don't say something, right? But I love this particular part, right? Like when evaluating the complexity of domestic violence relationships, not every case will be the same. Unlike drug or alcohol addiction, there are no Alcoholics Anonymous meeting cards, coins, or clean tests to measure success of a victim of domestic violence, right? And then the next piece of this, which I also think is incredibly important, is this is talking specifically about credibility, but what it says here is that we expect victims to be sweet, kind, demure, blameless, frightened, and helpless, and not multifaceted people who may or may not experience fear and anger. And we bring those preconceptions into the courtroom when we are talking about assessing the veracity of a person's story. And I would argue that this actually applies across the board, right? Even the most well-intentioned folks get stuck in this cycle, right? There's always the difficult client, right? The difficult client who doesn't just take services and who doesn't just accept everything you tell them and who doesn't just immediately trust you, or who, makes a different choice from what you think is right, right? Or the client who has come to you after already doing things that may make them, look bad or may have hurt their situation, right? And maybe you have a little more distance with that person, or maybe you don't feel like you can protect them or have as much responsibility to protect them because they've already made choices for themselves that you think were mistakes, right? So not only is it important to understand that that gets in the way of our own ability to provide services, but we know this is what survivors are experiencing in other places too, right? So part of our responsibility in keeping confidentiality is understanding the places where, because of these perceptions, they're not going to get as much protection, or there may be bias, or there may be other situations in which it's going to be more difficult, right? It's not that simple to just send somebody to go sign up for CalWORKs, or send somebody to go get their driver's license, or send somebody to do this or that, right? There has to be a conversation, because for survivors of domestic violence, they have to carry around a lot of this baggage with them, right? Any questions or thoughts about that? Okay. Susan, I actually have no idea what time it is. So if you can kind of just keep me on track a little, that'd be great.
You're doing great. It's 10:51.
Okay, great. Fantastic. Okay. And then building relationships of trust, right? So what is involved in building a relationship of trust? Taking time. And that's the one thing that so many of us are not allowed to do, is take time, right? We are under this constant pressure to move through, to meet deliverables of numbers of people, to meet cases, to meet that kind of thing, right? And yet that's actually completely the opposite of what's needed in order to actually build a relationship of trust, which should be a cornerstone of confidentiality, right? The whole purpose of a confidentiality is to encourage disclosure. In order to encourage disclosure, you need to build trust, right? And building trust takes time. Right? Verbal, visual, or in-person interaction, right? Not always. You know, some people are able to build trust over email, but sometimes it does take a phone call or a FaceTime call or a Zoom call or a, you know, I can tell you, you know, we're a statewide organization, and even though we don't go into trial court with a client the way a trial court attorney might do, you know, having a visual conversation with our client makes a huge difference, even though we're never going to go to court with them, or we're not going to be regularly meeting with them in person. Having those conversations by video helps both them see me as a person, you know, and hopefully someone that they can trust, but it also means that I'm seeing them and they know they're being seen, right? Explanation of the written word, right? So this is another thing where, and I will say this because I think the legal profession is partially responsible for this, but we think that if we put it in writing, we're giving the information. And the reality is that we don't know, and that's not necessarily true, right? How many times have you been in a situation where you basically have to hand a stack of forms to somebody who's coming to get your help, right? Fill out this, fill out that, read this over, ask me if you have any questions afterwards, right? Sit there in the waiting room and read this long thing and then ask me if you've had any questions. Anybody who's been to a doctor's office or a dentist's office or any kind of thing like that has to know what that's like, right? You get that huge long thing that's in like 8-point font, single spaced, and you know, it's not even on a regular size piece of paper, and you have to keep like going through and all this sort of stuff. And then, you know, usually by about a third of the way through, you're just like, I don't care, I want to give up, right? And you sign it. Or how many times have you been asked in the course of using your computer, you know, to accept a new user agreement, right? And it's like, oh, we'll email it to you. You can scroll down this whole window and read the whole thing, or you can just check that box that says, I agree, and move on with your life, right? So we know that in our own lives. So why do we expect it to be different for someone who is a survivor of domestic violence or a client we're serving, right? Why do we assume that because we're giving them a form or because we're giving them a piece of paper that says, this is what I'm going to do for you and this is what I'm not going to do for you, that is what that's going to be enough, right? And again, that goes back to taking time, but it's another way in which we sort of try to take shortcuts a little bit. There's nothing wrong with putting things in writing. That's very helpful for some people. There's lots of different adult learning styles, lots of different ways adults absorb information. And you want to have those options, right? Some people need to be given something and then come back later, right? And that's where repetition is also important, right? You might be working for someone for 6 months, 9 months, maybe you're working with them for a year. Did they remember the forms that you gave them at the beginning when you first worked with them? Do they remember what exactly the information is that they can tell you that'll be protected? Not necessarily, right? So repetition, talking it through, leaving space and time, right? To come back, to review, to refresh. Those are all part of building relationships of trust, okay? And then this goes back to that other slide I had, honesty about whose interests are served, right? Who are you there for, right? And if there's somebody else or something else that has a priority in terms of your obligations, are you being honest about that with the person that you're working with, right? The person that you're asking to trust you with their private information, right? Honesty about the limitations of your role and your agency, and support to find resources that are outside of your scope. This is another thing that I think is incredibly important, because it's very easy to tell somebody you can't do something, right? but being able to help someone find some place that can, if that even exists, you know, means that that person's being heard, right? There are lots of limitations that are placed on us, some of which we are glad for, some of which we hate, but they're limitations nonetheless. But being clear about that from the beginning is so important, right? You could be the 5th person that a survivor is encountering, that you could be the 1st person, right? And depending on who you are and depending on them and the situation, everything may be pinned on you in someone's mind, right? You are the person that's going to solve everything. You are the person that has all the ability to make everything easy, explainable, and you know, you are the person who can make the decisions, right? And in most cases, that's not true, right? And you don't want to set it up that way from the start. And then this, you know, this I don't mean in any way to be condescending, but the fact of the matter is, fulfill any promises you make and keep your word. Keep your word, right? Don't say you can call me anytime, and then when they call you, say I can't talk to you, right? Don't say I'm here for any questions, and then later on say, you know, I don't answer those kinds of questions, or that's not what we do, or that's not my job, or, you know, whatever. And I'm not saying anyone here does that, of course not, right? Most of the people, everyone who does this work is so dedicated and so committed and makes their own sacrifices to do this work. I clearly understand that. But this is just a basic thing that I think both we can do, but also if we know that a survivor is working with others, they may or may not be experiencing this, right? And that affects their ability to trust you too, right? Any questions about that? Okay. And then the last is who knows their best interest? And this gets back to what someone was talking about, self-determination, right? So when we talk about agency, right, what do we mean by agency and why is that important? Why don't, when, you know, someone comes to us and says, you know, I'm experiencing abuse, I need help, why don't we just give them a list and say, you do this, 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 this? Why don't we do that? Or why should we not be doing that?
Because they're already overwhelmed with what's going on in their life or their problems. I mean, just kind of letting them know what they need to do is just adding to their pressure, you know, whatever. I would think.
Yeah, that's one way of looking at it. I mean, I think, you know, you are going to have someone who will say, okay, thank you, I'll just do whatever you say, right? Because there are so many decisions, there are so many things that are overwhelmed about. And for some people, it's a relief to have someone else do it, right? But even in those situations, why do we want to prioritize victim survivor agency?
So Leslie says sense of purpose, value, and empowerment.
Mm-hmm. Mm-hmm.
Because it's their lives, their decisions, their choices, and their privacy.
Right. Right. And that's why, the reason why I say that is because, again, you know, it may seem like that's obvious for someone who works for a domestic violence agency and providing services, but it's still important, even if that's not the agency that you're in, or is that's not the direct work that you're doing, to think about that concept, right? How are we helping someone to become their own best advocate, right? To make their own decisions, right? And again, going back to some of what the ways we talked about in which privacy is abused, what's a really common thing that people say when they, you know, are describing what happens in their abusive relationships? They're told that they don't know what they're talking about. They're told that they don't know anything. They're told that they're stupid, they're crazy, no one's going to believe them, you know, all kinds of things, right? So survivors don't necessarily come to the situation knowing if they should be trusting their own decisions, right? And you don't want to be in a position of reinforcing any ideas that their decision-making skills cannot be trusted. And also, you want to be a part of anything that's going to reinforce helping them to make the decisions that they want, right? Because eventually, you know, that's what's going to have to happen, right? It's the whole like teach a person to fish type thing, right? Eventually, you want that person to fish, right? Because they know best. They know what they want to eat. They know where they want to go. They know how they do it, all of that sort of stuff. We don't know any of that, right? So giving them a fish doesn't really do too much except for in that immediate moment, right? Deciding for them what they're going to eat is not a long-term strategy. Okay, maybe I overdid it with that metaphor a little bit. But okay, and then, you know, we use these words very lightly, right? Sometimes survivor-centered, trauma-informed, right? So let's talk about that a little bit, right? If you are an agency that is supposed to be doing a public good, right? Doesn't that mean you should be trauma-informed and survivor-centered, right? Even if your exact work is not, I'm helping this particular individual who's experienced abuse, you know, your larger work is something else, or, you know, you're looking more at family relationships, you're looking at the person who's been abusive, you're working with the whole family. Doesn't it still need to be trauma-informed, right? And survivor-centered? And if that's the case, you can't ignore this issue of agency, right? So even when you don't have the exact same obligations and the exact same responsibilities as, say, maybe a domestic violence counselor or maybe a physician or maybe somebody else, these concepts are still important. And I think that there are still things that if we actually are really committed to holistically providing solutions to end domestic violence, we all need to think about, right? Okay, so just a quick sort of what makes confidentiality policies work, explanations up front, helping those you serve to keep their information confidential. One of the things that, you know, if you may have already experienced this a lot with your own work or your life experience, but certainly one thing that really became clear for people who didn't know these issues during the pandemic is the fact that people don't automatically have a place to keep things, right? We kind of assume that we give people a bunch of forms and pamphlets and stuff, and they have some place they can keep them, and that place is safe, or that they have the ability to print out the PDFs, or they have the ability to, you know, have a place to have a phone call with you, right? You're saying, oh, call me anytime, but do you know if they ever have a place where they can safely call you? Right? Those are the kinds of things that, so it's a little bit more than just saying, okay, I have a responsibility. Part of my responsibility is helping you figure out how you are also going to keep your information private, so I can help it be confidential. Right? Any questions on that, or?
I think Pamela shared that victims have had so many choices taken away.
Mm-hmm.
So we want to respect their choices. So I thought that was something very poignant that, you know,
Absolutely.
should be stated.
Absolutely. Absolutely. And I think that again, just to add on to what you're saying, Pamela, I think that that's a concept that isn't limited to being a shelter or a DV agency, right? That's a concept that can be throughout programs that work with survivors of domestic violence. Okay, so we're going to talk about privileges now and understanding legal privileges. And I'm saying legal privileges because privilege, as we know, is used in many different ways. We have that term in our general dictionary of words, but in this particular context, it means a very specific thing. It's a legal or evidentiary privilege, right? It's a law or statute or other binding rule that prohibits disclosure in a legal action or proceeding of an individual's private information without their consent or against their will. Okay, so what does that look like? Examples. So state law creates legal privileges that protect client information, right? So there's no domestic violence, there's no innate domestic violence counselor victim privilege. There's no sort of like commonly understood domestic violence counselor privilege. It has to be created by law. and California is a state that's chosen to create one, right? That doesn't mean that you still don't have responsibilities to keep information confidential. As we talked about, we have this federal law, et cetera, right? But when it comes to this specific issue of privilege, right, which means prohibiting disclosure of private information in a legal proceeding, that has to be created by something, right? And in this case, that's created by the state of California in these laws, right? So we have domestic violence counselor privilege. We have a separate one for sexual assault counselors, human trafficking counselors. You've probably heard of these other privileges. Of course, you know, I talked about a little bit about attorney-client confidentiality, attorney-client privilege is there, psychotherapist patient, doctor patient, et cetera, right? These are all laws in our evidence code. So where are they? They're in the evidence code, right? And why are they in the evidence code? Because it's all about what can be evidence in a legal proceeding, right? So what is evidence? Evidence is anything that makes something more likely than not, or anything that tends to establish the truth or not truth of something, right? In a very, you know, sort of just simplified way, right? Something has to be something that's going to help the decision maker, usually the judge, decide whether or not something did or did not happen, and whether or not something did or did not qualify as breaking the law or upholding the law, right? So when you look at it in that context, it's so much more narrow than what we might think about when we think about privilege, right? It is not that we're all walking around and privilege is everywhere. Privilege is very legal privilege and evidentiary privilege, not life privilege, sorry. We may be all walking around and there's life privilege, but legal privilege and evidentiary privilege is very specific and narrow, right? And again, let's get back to the goal. And this is written into the law itself. If you look at the law, you'll see what it says this: encourage victims to seek counseling and help them by enabling them to safely and confidentially discuss their situation and options with a qualified domestic violence counselor, right? That's the goal, is to promote safe disclosure as needed to help them get safety, right? And access services. So it's not a absolute privilege, and we'll talk about that in a second. So generally, privileges apply to testimony or records. So testimony can be oral, it can be written. Records, it generally applies if there's a legal court matter, an administrative hearing, such as workers' comp or housing, that type of thing, another type of proceeding. But it only applies if the information is in fact kept confidential. So that's where you get back to this idea as how are you fulfilling your responsibility, both to keep information confidential, but help your client keep that information private, right? In general, privileged information should never be released to a third party without a client's consent, even when the request is not made in connection with a formal proceeding, right? So the fact that it's not a legal proceeding, it doesn't mean that the privilege applies, but it doesn't also give you more rights to disclose that information, right? So what are a victim's legal rights under a privilege? They have the right to refuse to testify about protected information, right? They have a right to refuse to disclose or produce a writing, object, or thing related to that protected information. And they have the right to prevent another person from testifying or producing the writing, object, or thing related to that information, right? These are all rights that the victim has. So let's just go over a little summary of all these concepts here, okay? So what did we say? We said privacy is the individual person's choice to disclose information. Confidentiality is protecting the individual's choice about disclosure. And privilege is a legal rule prohibiting the disclosure of private information as part of a legal proceeding against someone's will or without their consent. So if you want to look at a visual of it, this is sort of how it relates, right? Like we talked about before, how this is the realm of private information, right? Information which a survivor has choices about whether to disclose. And then confidential is the information they've chosen to disclose to you that you have a responsibility to keep. And then privileged is a subset of that information, right? Because not everything is going to be in a court or legal context, right? And it only applies in that context. So it's very important to not sort of throw it around as something that's going to apply in every situation, right? Because it doesn't. And absolute privilege is something I'll just talk about later, but this is a privilege that doesn't have exceptions, and domestic violence counselor privilege does have exceptions. Okay. So the difference between confidentiality and privilege, okay? So legal privileges protect information that's confidential, but all confidential information is not privileged, right? So you have the circle of confidential information is bigger than the circle of information that's privileged, because it has to be used in a legal context, right? So it has to be used in a legal context. Otherwise, it's not, the privilege does not have a use. It's not, there's no purpose for it, right? Because again, it's about evidence, right? And what do you need evidence for? You need evidence generally in a legal proceeding. So for example, a domestic violence counselor, difference between privileged and confidential. When you get a subpoena or a court order demanding disclosure of confidential information, right? There you can assert the privilege because it's a legal proceeding. And so information that a court or, requesting information in and of itself, you can assert that privilege, okay? Now, there are times when courts may order the confidential information to be disclosed, and we'll talk about that. But in general, you're only talking about the privilege when it comes to something happening court-related. So what happens in real life? Yes, it's great that California has these privileges in our law, but most challenges to client privacy occur in daily life where privileges in the courts are not involved. And often in these situations, you have circumstances where there may be some initial involvement of the court, and then there's no court involvement for a while, and then the court stuff comes up again, right? None of these things necessarily move very fast, right? So that's why it's even more important that on a daily basis, in daily life, in your general practices, that we not only have practices for us as agencies and individuals, but we have proactive efforts to help survivors protect their privilege and confidentiality. Sorry, there's a missing word there. Try your best to keep things simple, right? And keeping it simple means just don't disclose, right? Don't disclose unless you actually have a court order or are mandated by statute. Someone have a question, or do you want to?
There was a question earlier, if you have any tips for helping your clients keep their documents confidential.
Yeah, that's a tough one, right? It's not so much that there's, I think, tips in advance, so much as you need to have the conversation, right? Like what's going to get in the way, and not assume, right? It could be that the client needs to keep what does the client actually need to take with them, right? What do they actually need to have in their possession, right? And where would they be able to put that? If there's not anywhere to put that, is there someplace else that can be stored, either someone else or with you or that kind of thing? But it's like safety planning, which we all know is a process and ongoing and kind of changes over time. It's something you walk through, right? Like, where is the place where you're living right now where you would put these documents? If you put them there, do you think that they would be safe? Would anybody else have access to them, right? Are you worried about someone seeing the information that I've given you, right? Kind of just talking those things through, because again, there are circumstances you're not going to know, right? You're not going to know that like the desk that they put everything in also happens to be easily accessible to this, that, or the other. They're going to give you circumstances about their situation that'll illustrate maybe some of the issues, right? I don't know if that's helpful, but
Yeah,
Okay.
so one more thing, actually,
Yeah.
we have a really good question from Rosemary in the chat box, but
Great.
before we go there, so RT, maybe we could just kind of illustrate with an example, like the differences among privacy, confidentiality, and privilege. I think your slide is very clear, but I think I would love to just kind of go over that in a like real life case scenario. So let's say if I'm a client, you know, I come to you, you're an attorney, my domestic violence attorney. I come to you because you have this great reputation and I just want a consultation because I'm not
Yes.
ready to file for restraining order or divorce, but I share information about the physical and emotional abuse I have suffered. So that information that I have is my private information and it's my right to privacy. Yes?
Yes.
And then what duty do you have that, you know, we discussed? So I'm asking you, please, Svarati, I'm not ready. I'm just sharing this information. You're my
Yes.
attorney. So you have
Sorry,
the
I'm listening. My battery's running low for
so
some reason.
you would have
Okay.
the duty of confidentiality. And you
Yes.
mentioned also responsibility that you have as an attorney.
Yes. Yes.
But
yes.
in your case, because you are an attorney, you have this additional legal duty under the Business and Professions Code and other
Yes.
ethical rules. But let's say
Yes.
I'm talking to my social worker,
Yes.
or let's say I'm talking to my sister or my friend, let's say one of you, right? I'm the victim. I'm just not ready to do anything, but I'm sharing this
Right.
information with you.
Yes.
Are you saying that you not even a social worker, because social worker has some sort of business license thing, but let's say
Right.
you are just you work at a local organization, you don't have any specific the licensing requirements, but I'm
Right.
just talking to you.
Right.
Do you still have the duty of confidentiality?
It depends. So first of all, it depends on if you are an agency that's qualified under the Violence Against Women Act or Victim of Crime Act, that type of thing, right? So even if you're not a lawyer, even if you don't have, you know, domestic violence counselor, even if you are, you know, not sort of necessarily involved in getting direct information, right? If you work for an agency that's receiving money through the Violence Against Women Act, through the Victims of Crime Act, through any of these other things, you have a responsibility of confidentiality, right?
Okay,
And it's a
so
federal responsibility, right? So that's why I think it's important not to, when I talk about keep it simple, right? Again, the issue, you know, normally it's just when in doubt, don't, or, you know, there's no reason you should have to unless it's XYZ situation, right? Yeah, so another example might be, let's take this. Okay, so let's say, for example, you know, I'm someone who's experienced domestic violence. I told my sister, right, you know, this happened, you know, my wife hit me, and I pushed her back, but she hit me, and now I want to get help, right? So you go, you know, I go to a domestic violence service provider, I go to an agency, right? And I say, you know, I'm not sure what I want to do, but I have this situation. My wife hit me. I need some help. I need to get out of there. What can you do, right? And the agency gets this information, and then they say, sorry, we can't help you because, you know, we don't provide services to people who live in that zip code, right? Or sorry, we can't help you because we can't verify your income, whatever that is, right? Then this person goes to another agency, right? And says, hey, you know, I'm in this situation. My wife hit me. I need to get out of there. I need to be safe, right? And in the process of sharing that information, they say, well, this last time what happened is my wife hit me and I pushed back, but she hit me and hurt me first, right? And I just did that to defend myself. So in that situation, first of all, right, the sister has no responsibility other than just like a moral, ethical, I love my sister kind of thing to keep that information confidential. If the court issues an order, or if there's a well, let's forget about the court order. Let's say if there's a court-ordered subpoena, right, or a subpoena that comes for the sister that says you have to come and testify, she will not be able to say, oh, you know, I'm protected by confidentiality, or I'm protected by domestic violence counsel privilege. None. Okay. Now, that same court or that same, you know, agency, maybe it's not a court, you know, maybe it's Child Protective Services or something like that. They go to the first agency and they say, you know, we know that so-and-so went to you first during this month, and then they didn't go and get help for another 3 months. So we know that they were trying to get help at that point, and then they didn't do anything. So we need you to tell us, you know, we need you to give us the information, right? When did they come see you? What did they ask for? Why did they leave? That type of thing, right? That information is confidential, first and foremost. So it would need a court order or a law, right? If the person that that I as the survivor talked to was also a domestic violence counselor, meaning had gone through the 40-hour training and qualified under that, there would be an even further protection, because they would have domestic violence counselor privilege. Okay. And then you get to the third place, right? Where the third person I told, right? And that it should hopefully be clear that that information is confidential and privileged, right? I told it to, let's say I told it to a domestic violence agency. I did talk to a domestic violence counselor. I told it to a domestic violence agency, it's confidential. I told it to a domestic violence counselor, it's privileged, right? Now, the tricky part is, does the fact that I told my sister this information mean that the agency that I also told the information has to say the same thing, right? And the reason why that's the case, and this is when it comes down to like helping to keep information confidential, right? It only applies to information that is in fact kept confidential and private, right? So if someone goes around and tells everybody that they know what happened and then tells you, that information is not private. That information has not been kept private. That information has not been only shared with you in the context of a confidential relationship, right? So by itself, that piece of information may no longer be something that you can keep quiet about if a court orders it. Doesn't mean you have to affirmatively disclose it. Doesn't mean you have to say anything about it. But if asked and it comes in the form of a court order, in most cases, then you have to think about that, right? I don't know. Does that help? Does that sort of? Okay. All right. What time is it?
It's 11:24.
Okay. And how much time do we have? 30 minutes?
Yep.
Okay. All right. So let's go back here. All right. So domestic violence counselor privilege. I'm actually not going to spend tons of time on this particular thing. There's a lot of aspects about it. And, you know, we could do a whole separate training on it, and it doesn't apply to everybody on this call too. So I don't want to take up too much time with that. But as we mentioned before, when we talked about legal privilege, we talked about, you know, this is an evidentiary privilege. This is about what information is given to a court to help them make a decision, what information someone's allowed to use to help a court make their decision, and who qualifies to be able to say, you know what, I can't give you that information because it's protected under privilege, right? Who holds the privilege? Generally, I mean, it should be clear based on what I talked about being the victim's rights, the victim's legal rights. It's the victim that holds the privilege, right? Holding the privilege means that you have the choice about the information. Claiming the privilege means you have to tell somebody that the information is covered, and so you can't do anything about it, right? Either you say, it's my information, it's covered, I'm not going to tell you, or you have to say, this information is covered, I can't tell you unless this person consents, or you have a court order, or it's, that type of thing, right? How long does it last? It basically lasts until the survivor has passed on, right? Unfortunately, we live in a world where, domestic violence is a leading cause of homicide among women. And so the reality that a domestic violence survivor will not survive and live a normal lengthy life is there, and it's happened. And I know, I wouldn't wish that experience on anybody, to have that client situation like that, but it's something that happens in our work. And so the privilege no longer exists after the person dies. So what does that mean? Generally, what that means is that in that kind of context, if someone was requesting the information, you would have to give the information, right? If it was a court order or if it was a thing, right? You couldn't just say, the only reason I can't give this information is domestic violence counselor privilege. Now, there's some debate about whether confidentiality applies after death. It's not clear in the federal law, but the best practice is to assume it's confidential, right? So outside the context of a court proceeding, you still want to keep the information confidential. In the context of a court proceeding, you may have to disclose some of that information because you can't claim privilege if the survivor no longer is alive. If that makes sense. Okay. So I'm going to, if you close your eyes for a second, I'm going to flip through a bunch of slides. So I don't want to make anyone dizzy. But when you get these slides, you'll see that there's a lot of information in here too about the privilege itself. And just some quick information, the information that's protected is what's called a confidential communication, right? So it's information exchanged in confidence, right? And that's another part of what confidentiality means, right? Is that you are working to help make sure that the communication you have with that person is in confidence, right? Kind of like what someone was saying, you're not having the conversation in the grocery store where nobody has any expectation that the information will not be heard. Okay. If your person you're working for wants to start to have that conversation, that's where you would come in and exactly like the person said, you would sort of steer the conversation to something else, right? Or literally stop the person right there and just be, look, this is not a confidential space, so I don't want you to share anything, right? It's a broad definition. It can be the identity of a client. It can be the name, address, phone number. Again, we talked about how disclosing a client's identity can reveal the fact that they suffer from a condition or are seeking services, right? And protecting identity generally is part of providing safe, candid forum in which to address problems. So what makes a communication confidential? A communication that's made in a manner which, so far as the victim is aware, again, it's about what the victim's aware of, discloses the information to no unnecessary third parties. So there's a lot of jargon in there, right? So let's try to unpack that a little bit. But what this tells you is that, again, not every communication between you and your client, if you're working with a client, will automatically be confidential if you don't take precautions. Right? You still have to take precautions, and your client still has to take precautions, and you have to work together to do that. Okay, necessary third parties. So sometimes, even in a situation where a third party is there, that party can be considered a necessary third party, and so the privilege still applies, right? Because normally, if you just have a third party there, it won't be privileged because, again, you're not making the communication in confidence. You're making the communication knowing that there's this third person there, right, who doesn't need to be there. So you don't have an expectation. You're not intentionally keeping information private. You're disclosing information that's
RT, you froze? Uh-oh. Or is it me? Hello? Can you all hear me?
We can hear you,
Can
already
hear you.
froze.
RT is frozen.
I hear you, but the other person's froze.
Okay.
Can hear you.
Yeah, so she's having internet issues. I'm gonna, oh, she'll come back.
sorry
Okay.
about that. I'm back.
Oh, there you are.
Yeah, I apologize. I don't know what's going on. My computer is plugged in and it keeps saying my battery is low. So I don't understand that, but we'll figure it out. Yeah, so necessary third parties. Okay, so what's a necessary third party? The third party's presence furthers the interest of the victim in the consultation. Disclosure is reasonably necessary to transmit information between the victim or counselor, or disclosure to a third party is reasonably necessary to accomplish the purpose for which the counselor is consulted. So let's talk about some examples, okay? Let's take this example. Disclosure to the third party is reasonably necessary to transmit information between victim or counselor. What might be an example of that?
An interpreter.
Sorry. Yes, exactly, right? Interpreter, right? You can't say, oh, because you need an interpreter, you automatically give up your confidentiality and your privilege, right? You automatically give up your privilege, right? That wouldn't be right. That wouldn't serve the purpose of the goal of getting victims to disclose, right? So that's one option.
RT, you're not sharing screen. Did you want to share your slides?
Oh yeah, hold on a second. Let me see where. Thank you, sorry about that. Thanks, sorry for all the tech difficulties on my side. So yeah, examples is a ASL or non-oral English language interpreter, oral non-English language interpreter, right? A caretaker or support person for a domestic violence victim who has a disability. A victim needs a third party's emotional support in order to get the help from the domestic violence counselor. Staff or volunteers who are not domestic violence counselors, but are working under their supervision and assisting, right? So if there is a third party there, you want to be clear about why that person was there. So let's go back, let's unpack this a little bit here. So caretakers and support people, that should hopefully seem pretty self-explanatory, you know, somewhat in the way of someone who needs an interpreter, right? If someone needs that person to be able to communicate with you, to meet you, to engage in your services and get your help, then that's perfectly allowed. This victim needs a third party's emotional support is a little trickier, right? I think we've probably, if we've worked with clients, we've probably all had that situation that's like, you know, can my sister come in? She knows everything already. And, you know, I really feel better if she's there, or I can't remember everything all the time. And so my sister will be there and she can tell you some of the stuff I forgot, right? We get that a lot, right? It's completely understandable, right? It's unrealistic to think that someone is going to keep everything from everybody the entire time when they try to seek help, right? People need to be able to lean on other people in their life who support them. You know, so many domestic violence survivors have no one, right? Or no family support. So if they have a friend or if they have someone who originally can help them, they'll use that. The key with that situation though, is whether that's ongoing or not, okay? You really have to be able to document that that person is necessary every time you're having that conversation, right? So it can't be, oh, Tuesday I had this meeting and the friend was there, and then, or my sister was there, and then Thursday I had another meeting and the sister was not there, right? Possibly, we've never had to sort of put this to the test, but possibly you could have a situation where maybe the first month or two that you're meeting with somebody, they need their sister there, right? And then after that, they no longer. But you can't have this in and out kind of situation. That's what's really important, right? And if you can explain it that way too, that also might help someone to understand, right? What the situation is, and just talk through, what is it that you're worried about? Okay, if you're worried about forgetting something, we're going to have more than one session. If you're worried about forgetting something, I'm going to be, repeating and reflecting back what you said. And so we can think about it, right? There's probably very little that if you forget it in that moment, we're not going to have a way to, right? So it's partially helping to relieve their concerns, and also explaining what the impact might be of having this person in there, okay? Staff or volunteers, again, you might have, maybe you have a client, I don't want to say social worker because that's a whole other different thing, but maybe you have like a client support person, right? In addition to you, right? A client can have a support person in addition to you, maybe through your agency, right? So that person can be there because they're working with you, they're working for you, they're under your supervision, and you have the privilege, right? This is particularly helpful when you have volunteers and when you have, people who are helping, but they're not full-time staff, or people who are not able to be there all the time, right? But you want them to be participating or learning. It's important as long as you're working under the supervision, right, and assisting in that particular case. Okay. Any questions about that? Okay. So we just talked about this, if they want another person present. In the context of law enforcement, one thing that's important to remember is that domestic violence victims are allowed to have both a counselor and a support person of the victim's choosing present in an interview with law enforcement or the district attorney's office, right? Keep in mind that those conversations are not confidential or covered by privilege, right? In the sense that you still have to keep the information confidential, but the district attorney has no obligation to keep it confidential or privileged, right? There's no privilege there that prevents the district attorney from using that information. And it comes right from the penal code. Now, law enforcement does have the ability to exclude a person if their presence would be detrimental, but we've had situations where domestic violence counselors and support people have to literally come with a copy of the statute in their hand to get the ability to sit in on that interview, right? But they are a necessary third party. Okay. Support groups. This is also a really important question, right? Support groups. If a victim discloses information in a support group, is that information confidential? And if it's confidential, can it be privileged? What do you think?
Well, I would argue that yes.
We will always argue yes. The default argument is always yes, it's confidential and privileged. Yes, yes. But the reason why the answer is yes, okay, is that it's considered reasonably necessary to accomplish the purpose for which the victim consulted the domestic violence counselor, i.e. to obtain supportive services that help the victim recover from abuse, right? All right, this, we'll just skip over this. If you're not sure that someone's covered by these exceptions, you need to advise the client that information shared with a third party may not be protected, right? Or if you know that they will be, they will be, right? Even if a third party clearly falls within one of the exceptions, it's always best to have them sign something, knowing that the information being disclosed is confidential and privileged, and that that they should not disclose it to other third parties, right? Meaning have the third party sign that. Sorry, that's a little unclear.
So Arati, there's a really good and important question in the chat about a situation where the parent comes with a minor who has experienced violence.
Yes.
Would you say the parent is a necessary party or not? That's kind of one general question. And then there's a specific question in the box saying, what would you do if the parent keeps interrupting? Would you kick the parent out?
Yeah. I wish I could say I hadn't had that situation. Unfortunately, I have. But so a couple of things. There is actually a slide later that I will get to that's about teen victims, right? But in general, it's a tricky issue, right? Because when you're talking about a minor, right, generally their parent or legal guardian also has the right to waive the privilege. Now, of course, we have situations where the parent or legal guardian is the abusive party.
Oh, you're frozen again. This is getting interesting and you're frozen. Hello? Sorry, everyone, stay here, please. And this is really the part that I think is getting interesting and important. And Arati is frozen again. And let's give her a minute. Oh, there she's coming back. You see? Technology works. Hello, you're back.
I have no idea what's going on. My computer is conspiring against me, so I apologize for that. So yeah, with the situation with the minor, essentially, what you're dealing with is that the parent or legal guardian is the person who has the ability to waive the privilege. Usually what we try to say is we think about whether, is it an agency that's already allowed to provide services to minors directly, right? So you can look at some of your funding for that. And then, yeah, I mean, hopefully it's a situation where, the parent is just trying to be supportive, right? But if it's a situation where the parent is interrupting and things like that, I mean, what I've tried to say is sometimes I've taken them aside, and said, oh, can I talk to you for a minute? And we'll take them aside and try to make that clear, what I'm trying to accomplish or what I need to accomplish or what needs to be accomplished and how that needs to go. Sometimes you can do it by setting boundaries up at the beginning, right? You can say, I know you really want to, support Arati here. I'm grateful that you're here. That's fantastic. I'm going to ask you, even if you know the answer to a question, to please let Arati respond, right? And let me ask the questions because it's very important that everything come from Arati, right? So you can kind of manage it in that way. Obviously, you don't always know if that's going to happen, but hopefully if it does happen, it's a one-off thing, right? Because either you've been able to, so my slides are now lost because I'm on my iPad, but I will send it to you. And there's not, I can talk through it basically what else I'm going to talk about. So in any case, so yeah, so that's would be my advice in a situation where you have a parent and a parent who's interrupting. But the parent would be a necessary third party in some cases, but they wouldn't be an unnecessary third party, right? Because they hold the privilege as well. Right. So that's going to be a tough situation. Again, a lot of these things might come down to argument, right? And that's why once something happens, unfortunately, the solution most of the time is to get a lawyer involved, right? So to figure out where are your lines, what can you argue, what can you do, knowing that your goal, hopefully your particular goal, is to not have to disclose, period, right? That's actually much clearer than if you're in a different situation, right? Where that's not necessarily your primary client, that's not necessarily your situation, right? That's why it's always a little bit difficult. But that's why we're also talking specifically about domestic violence counselor privilege, right? And not just all confidential information. Okay. Any other questions? Okay. So as far as the rest of it goes, basically what I wanted to talk about is informed consent. And there's a couple of issues about informed consent that I think that are important to know. One is we really have to go back to thinking about what builds a relationship of trust with someone when we're talking about informed consent, right? And what are the possible circumstances or situations in which someone might feel that they have to give consent, whether or not they really know what they're doing, right? We talked about all the situations for us, right? The computer and the, I still remember one of the first things that happened when I went to law school is our professor said, did any of you park in the parking garage? And people were like, yeah. And they're like, have you ever read the back of your ticket, right? If you read the back of a ticket from a parking garage, you know that basically just by entering the parking garage, you've given up all your rights to sue them for pretty much anything, right? Like somebody could go and yeah. So if you read the back, right, it's like this parking here does not create any liability for us for anything, right? But nobody sits there and pulls the ticket and reads it and then says, okay, I'm not going to park there, right? They just go. And that's what most of life is like in some situations. But in particular, in a situation for a survivor who's having to go to maybe 3 or 4 different places, right, to get help, the understanding of, do they have a choice in this situation? Can they narrow their choices, or can they narrow the information that's being requested? May not always be clear, right? So even when you are doing your best to provide informed consent, helping a survivor understand what informed consent even looks like so that they can apply that in other situations is particularly important, I think, right? And so what do we talk about when we really talk about informed consent, right? So the best practice for informed consent is, first of all, that it's in writing, right? But again, we talked about how writing is not the solution for everything, right? So yes, you can have something in writing, but hopefully the writing is not where you start. You start with a conversation, or you start with the writing with the conversation, right? And you fill the writing together. Okay, or you fill the writing in, or you have the writing in such a way that they've had some time, right? One of the things that always frustrates me is when you see these settlement agreements, and it says, I've had the opportunity to consult with a lawyer and have had all my questions answered, right? And that's not always true, right? But you kind of get stuck signing that because it's more of a like cover ourselves, right? And that's sometimes how these issues have been looked at, right? It's more about like covering ourselves from liability or that type of thing. But really, again, getting back to the purpose is to get people to come to us for help, right? So informed consent writing, right? And a big key of writing is that there's limits. One of the big problems that happens, particularly with public agencies, but even with domestic violence agencies, is blanket waivers, right? Blanket waivers go against everything that we know about survivor autonomy, about protecting confidentiality, right? Because what a blanket waiver says is, you decide now that for now until the end of time or the end of when I give you service, in every situation, you're okay with me having information. And that just is not true, and it shouldn't be true, right? We're in a situation where hopefully a survivor is developing their own agency to the extent they don't have it before. So why would you make them do something right in the beginning that says, you know what, when it comes to this particular issue, you just, it's now or never, and that's it, right? So that's one big problem. Writing, it should be specific as to the place, the person, and the purpose. So it's not, I agree to disclose the fact that I agree to disclose the fact that I took a parenting class at a domestic violence agency to the Family Justice Center. You don't write informed consent like that. It's, I agree to have the information that I went to a parenting class at this shelter disclosed to Susan Kim, who is this person at the Family Justice Center. It is for exactly 1 week. And it is only for the purpose of making sure that there was a parenting class at the agency. It's not for any other purpose. I'm not intentionally or knowingly disclosing anything for any other purpose. It doesn't apply after a week, right? If the information is not disclosed during that week, you still have to get permission. If you disclose that information that week and you try to get it again, you're going to need a new informed consent, right? And this is also really helpful too, because you really think about then, again, what's the purpose? Most people don't always need all the information they ask for, right? They're sort of like, give me everything and then I'll figure out what I need. And for survivors, that's dangerous, right? So people need to be able to specifically say what they need the information for and why they need the information. And this becomes particularly important in the context of working with, say, another public agency, right? I've had situations before where, you know, I've worked with people who they say, you know what, this agency has called me and said that I have to tell them if this person is coming here for support groups. And when I tell them I can't, it's confidential, they'll say, well, you know, you're only hurting them. You know, you're only hurting them. I'm trying to help them and you're only hurting them, right? No, that's actually not true. You would be hurting the other person. You would be hurting your client, first of all, but also, you know, you don't need to be making those decisions, right? That's for your client to decide. Okay. So I think that's one way in which we get pressured in our work to make it seem as if we're all on the same side doing something, but we're not always on the same side doing something, right? And that's where we may have an extra responsibility to push back in ways that our client may not expect, but that's part of our responsibility for confidentiality, right? Yeah, so basically, again, we want to say, we want it to be in writing. You want it to be specific as to the person. You want it to be specific as to the context. You want it to be very specific as to what the information will be that will be disclosed. You know, you don't want to be saying a file, or, you know, you want to, maybe it's an attendance record, or maybe it's, you know, one meeting or something like that, right? You want to keep it as narrow as you possibly can. And you want to keep it time limited. Time limited is your best friend, right? Because that prevents exactly what we're talking about with these blanket waivers, right? And frankly, this is the other reason why it's important to use informed consent in this way, is that you are able to then have pushback when you do get a blanket waiver, right? So when you get a blanket waiver and you know that your client did not actually understand what it meant for that, or they didn't actually have informed consent, or et cetera, you have the ability then to push back at that time period and say, no, you know what? Unless I get informed consent from my client, I'm not giving you that information. I don't care what waiver you gave me. You know, your form, a lot of the forms you'll see from some places, you know, don't even include the basics about informed consent. So it's really important that we not take consent lightly, and that we really understand what it means to be informed. Informed also means, again, what are the consequences, right? And if you're not sure of the consequences, you need to say that, right? We can't always predict every situation in which something is going to be, right? But we need to be open about the fact that we may not necessarily know, or that we, you know, that there could be situations where it might come up again, and the fact that there was consent given in this particular situation may become an issue, right? So go ahead.
We have 5 minutes left.
Okay.
So there's, I think, one question in the
Yes.
chat with Swastika's question. So Swastika, do you want to ask the question? Unmute yourself.
Thank you so much for your informative presentation. And this is what
thanks.
we really need. My question is, I had a client who provided me like 12 or 13 pages of confidential information that was that happened, email conversation that happened between her and her attorneys and a bunch of other service providers who were helping, and she requested that information to be included in restraining order. As a service provider, am I And there is disclaimer in the email saying you are not allowed to use this information in any other circumstances. Am I allowed to use that information for filing a restraining order or any other, provide her any other service based on that information? Does CA law permits service agencies to use that?
Well, I don't want to speak on any particular situation without knowing the I mean, I'd have to sort of read everything, but I can tell you a couple of things. So first of all, you would never be putting any, so, you know, just separate from the issue of what information, anything that goes in a restraining order should be something that the client wants to go in the restraining order, and you are taking their information and putting it down as they want it. If you are filling out a restraining order yourself for someone else, you are doing an unauthorized practice of law, right? So you don't want to be doing that. You know, you don't want to have a situation where a client's like, this is what happened, can you put this in a restraining order for me? That doesn't work, right? So the fact that they gave you information that they want you to know, and that information may be useful for a restraining order, is different from whether you have the right to use that information in a restraining order, because what's in the restraining order can only be what they want, right? And it's a public document, right? They may want to think about, do I want to talk about all of these things? Do I want to give this much detail? Of course not, right? You want to start with the basics, right? And then go from there, right? Second, the fact that there was some communication with an attorney can be problematic. That's also because the attorneys don't always do a good job of explaining this type of thing, but arguably you are also a necessary third party, right? Like if this attorney may, let's say, for example, like Susan said, you know, I went for a consult, but not representation. And they said, well, you know, I can't represent you, but you can go to this agency and they have a clinic and they're going to be able to help you fill out that restraining order, right? That's information. That's a necessary third party. That's an information that is necessary to get the services that they need from you, which is in this case, help to file a restraining order, right? So that information will still be protected in general, okay? But yeah, that's actually, it's, you know, it's a wonderful point because we have that happen all the time. Before we even have the first conversation, sometimes you get all this information. And, you know, or sometimes clients don't know what do they need to share with you, right? And so they think I'll just share everything. And it's so much easier to just forward a bunch of stuff than it is to sort of go through and think all that kind of thing. So you do want to talk about that, right? You want to talk about those scenarios, and that's what takes time, right? That's what takes time. You know, maybe you say, don't forward me anything without talking about it, right? Or don't, you know, if it's from your lawyer, don't forward it to me, or, you know, whatever it is, right? And just have that conversation first when you're talking about confidentiality and privilege, right? And say, you know, I know you want to share this with me. I know you may think that, you know, you need to give this to me. Maybe you're worried I won't believe you if you don't give me the exact language or something like that. But I'm asking you, for both of our sakes, don't forward it to me, right? So I'm assuming my 5 minutes are up. I truly apologize. I'm so sorry for all of the technical difficulties on my end. I don't know why that's happening. I'm going to have to look at my computer. It's plugged in completely and it just kept saying no battery. So no idea, but I really appreciate everyone who stayed on and your patience and your kindness. And there's a lot of things in the PowerPoint that I sort of alluded to, but that are in more detail. So hopefully you can use that as a little bit, thanks, Erica, that you can use it as more of a checklist. What I'm gonna do too is I'm going to put right here my email address. So please feel free to reach out to me if you have questions about the training, or if you read the PowerPoint